Today I'm going to educate you about the Missouri workers' compensation system. I first blogged about this probably 10 years ago, and I've had tens of thousands of views. So I wanted to update both the law and the facts in light of today's climate. You can find this blog at the Cantor Injury Law page, and I appreciate you being here. Workers' compensation is a conspiracy. It starts the moment that you're injured and your employer comes out and wants to take a drug test of you. Why do they get to take a drug test then? The reason is that the big government, large insurers, and large employers got together and made laws that are favorable to them. So immediately they want to drug test you because if you test positive for drugs, for instance, they get a 50% penalty. That's a penalty against all of your benefits. It affects you and your family. So they come in, you've got an injury, they want you to fill out a report of injury, they want to drug test you right away, and they want to take statements. If you have a severe injury, they may send you to the doctor, but they'll send you with a nurse case manager. That nurse case manager's job is not just to get you better, but to whisper into these doctors' ears as you go through the process to release you. You know, release Joe from medical care. He's okay. Send him back to light duty. And we're going to go through all of this today, and it's going to be a long video. I'm going to tell you how to win a case, and I'll tell you how to lose a case. If you've never tried a workers' compensation case and lost, you're not doing it right. I've been doing this since 1993, and there's a lot of ways to lose. The biggest way to lose is to lie to your lawyer. Don't lie to me. I don't have the time for it. I've had cases where we're in the middle of trial for a shoulder surgery case, and my guy's giving depositions about how his shoulder hurts him all the time and he can't use his shoulder. And then we're going to trial and they have a video of him fast pitch baseball. That's not my fault. Don't lie to your lawyer. There's an opportunity to resolve that case, you resolve it. We're not saying you didn't hurt yourself, you didn't have the surgery, but you can't lie about your disability, so don't lie. Follow all your medical care. Okay, if you're getting reasonable care, even if it's from the company doctor, you need to get it. But you got to understand that these doctors work for the insurance companies. In Missouri, the employer gets to choose your doctor. That's part of the conspiracy. This is America. We think we should be able to choose our own doctors, not in workers' compensation. You may have a right to use your private insurance, but your private insurance is probably funded by your employer, and they're going to say, no, we're not paying for that. It's a work injury. So after your injury, they come in, they want a statement, they want you to sign a report of injury, and they want to send a nurse case manager with you, and they want to drug test you. What should you do? The very first thing you should do is get a lawyer. Lawyer up. You're outmatched. Some people don't want to. They love their employer. It's my friend. Well, guess what? It's not them that's cheating you. It's their workers' compensation insurer. If you have 5 or more employees in the state of Missouri, you got to have workers' compensation insurance. Even if it's your best friend, they're going to go out and have a separate workers' compensation insurer that doesn't want to pay you. You're not hurting them. You have a legitimate injury. And by the way, I only want your case if it's a legitimate injury. And I'm not making this film and educating you about workers' compensation necessarily to get your business. We have plenty of business. I don't need bad cases in this office. If you stubbed your toe, get over it. Okay, you got to have permanent and partial disability. I don't want that case in this office. But if you have a real injury, that's what we're talking about. I'm never telling you to lie or soup up your medical. You don't want to lie. That's the best way to lose your case. So these medical doctors are beholden to the workers' compensation carrier. They get, you know, thousands of cases from them. They treat those cases. They get paid by the employer, and then guess what? At the end of the case, they say you don't have an injury. You know, you had a shoulder surgery, you got a 1% disability. They did an MRI, and they say your shoulder tear was there, and I fixed it, but guess what? It's an old tear. So these doctors know how their bread is buttered, and they're helping the insurance company so that they can get more business. So they treat you, then they release you, and they say, I fixed you. And guess what? Workers' compensation doesn't pay for pain and suffering. That's part of the conspiracy. They only pay for permanent and partial disability, which is commonly called PPD. And the money, and so they won't owe it if you're better. So these work comp doctors do all this treatment, they make their $50,000, $100,000, and then they say you have a 1% disability. And then the trick is, don't get a lawyer, they tell you, we'll offer you 5%. And we're going to go over the meat chart in a minute. We're in the conference room of Cantor Injury Law. We've got video technology. I've got a what I call the meat chart projected onto the screen. We're going to talk about that. But I want to talk to you about this conspiracy a little bit more. So I have one of the largest wins in Missouri workers' compensation history, and it's still used today. It's the case of my client, Dale Weeda. And Dale injured himself while at work. He herniated his L4, L5 lumbar disc. And the company sent him to a doctor, Dr. Peter Merkin, and Dr. Peter Merkin treated him. And while my client was being treated, the insurance company sent private investigators out, and they filmed him. They videoed him. Guess what they got? Nothing. They got him sitting on his porch because he couldn't move because he had a herniated disc in surgery. And by the way, they tried to hide those videos from us, and we got them. I used them at trial to show that he in fact was disabled. But you got to be careful. After an injury, these insurance companies will stop at nothing to defeat your claim. So, you know, they'll send a car out with tinted windows and they're filming you, okay? And anyone that tells you that they're not doesn't know. I've done it since 1993, and over the last 27 years, I've seen many of my clients in both civil, like a car accident case, as well as workers' compensation cases being videoed by the insurance company. So don't kid yourself, they do that. At any rate, Dr. Merkin did this surgery, and he testified that my client's back didn't heal, didn't fuse, because my client was diabetic. And he said that he talked to my client about being compliant with his diabetes medication, and that's why my client, Dale Weeda, failed to fuse. Well, I deposed him for a long time about that. I had this doctor who works for the insurance company repeatedly testifying about the diabetes and how that was the cause of my client not healing. But guess what? My client didn't have diabetes. So that was not untrue, completely made up. The court stated that he was biased and uninformed. And there's other cases similar to that, where a court found that, quote, Dr. Merkin has previously materially changed his testimony to suit his employer and has fabricated medical conditions in order to suit his indefensible opinions. That's a case, Abodi at page 4. There's another case, Ottinger versus Roadway Express, where they accused the doctor of being, quote, laden with falsehoods and, quote, utterly unworthy of belief, close quote. So don't think that just because the work comp folks sent you to a doctor that they're going to treat you fairly. And I've just given you a perfect example of a doctor that was caught misinformed, biased, uninformed, and not credible. Some people would call that a liar. The fancy word for liar is malingerer. And these doctors frequently will say in their medical reports that the claimant is, quote, a malingerer. That means they think you're lying. So it's kind of ironic that in these cases the court found those things. I've seen other cases where doctors missed a rotator cuff tear completely. When they were shown it on an MRI, they basically denied it. And you know, I tried the case with other doctors, and the courts agreed with me when another doctor looked at that same MRI and say, there's the rotator cuff. So just because you went and got a study, an MRI or CT scan, and they say you're fine, it doesn't mean you are. You need a lawyer. I had a case, TH versus Sonic drive-thru. It was a very sad case where a woman that worked at Sonic was raped as a result of her work. We set the precedent for what's called rate, R-A-T-E, how much you get paid. That was some years ago. But in that case, their doctor had an outrageous and carefully crafted position that suited their psychiatrist's opinion that the rape was consensual and not an assault. And of course the court disagreed, and we won that case. I've also lost cases. The way you lose a workers' compensation case is you act unreasonable. You think you get money for pain and suffering. You don't. You get money for disability. So you might have a guy that has carpal tunnel surgery and their hands are numb and tingly and they're weak forever, and they think they should get $100,000. Well, I'm going to show you on the meat chart how the math works, and it just doesn't work out. So you may go try that case and get less than what was offered, and that, my friends, is a loss. So sometimes you do that to appease your client. You know what? Makes all the other cases in your office go up in value. If a client wants a trial, I will try their case. I may not recommend it, but sometimes you lead a horse to water, but you can't make them drink. So you just go in and you try the case. There's other times where people want to settle, and I tell them not to, that it's too little, that we should go to hearing. You can't be afraid to try these cases. You got to take them to trial. The insurance companies know which lawyers are trying these cases and which ones aren't. At Cantor Injury Law, we have 7 lawyers. We're all capable of trying these cases. I primarily handle the complicated cases, and I go to trial routinely. So if you have a case and it needs to be tried, we will try it. One of the other ways that workers' compensation cheats is that they provide you with surgery, and the doctor says it was a successful surgery, but while I was in there, I determined that the need for surgery was unrelated to the work injury. It wasn't an acute or sudden injury. It was over time, arthritic, for instance. And so although we've paid for the surgery, we're not going to offer you any money. Or the adjuster says you got a 1% rating, but we're going to offer you 3%. I might send you out to our doctor who might say you have a 30% disability. The case might be worth 15%, but without a lawyer that has a doctor that can send you to for an independent, honest medical evaluation, you don't know the value of your case. You just don't. And part of this conspiracy in workers' compensation is fancy and complicated math. And I'm going to show you that math in a minute when I stand up. So I talked about these nurse case managers. They act super friendly to you. Frequently, they're not on your side. They're trying to get you released back to light duty. And that's another trick. They said they have light duty available to you and you don't have a lawyer. You've got to go into the office and count rubber bands all day. And you say, I don't want to do that. I like to be outside, and I hated school, and I don't want to sit in a room and count rubber bands. So you don't. And then they fire you. Guess what? You're out. If they release you to light duty and you don't have a doctor that takes you off light duty, you will get terminated. You got to do the light duty. People don't like that, but that's the conspiracy. That's the law in Missouri. If you come to me and you say, Mark, they released me to light duty and it's a 5-pound restriction, you got to work within 5 pounds. Now, I have a lot of cases in this office, and one's going to go to trial soon, where they say the restriction is 10 pounds, and you got a restriction of 10 pounds, and they're trying to have you do 20-pound work. Well, they can't do that. So if they release you to light duty and have light duty within your restrictions, do it or get terminated. Once you get terminated, they don't owe you benefits any longer. Sometimes people come to me and they say, Mark, we don't want to file a comp claim because if we do, they're going to fire us. Well, that's illegal. Okay? They cannot fire you exclusively for pursuing a workers' compensation claim, but the law in Missouri got tougher on that. The reason for the termination must be the exclusive reason. The language is the exclusive reason for the termination must be workers' compensation. Then you have a cause of action. But if you're late and you have a comp claim, you don't win that case anymore. So for a while we were handling those and doing very, very well for our clients. But the conspiracy kicked in, and big government got together with large insurers and big business, and they cut that out. So if you're terminated exclusively because of your workers' compensation case, and that takes like a bold statement, like we're firing you because you filed a comp claim, we will handle that case. Here's another big conspiracy. They say you fell, let's say, from a scaffold, and you weren't wearing your safety harness, and you broke your back. They're going to offer you 50% of what they would have, and the law stands behind them. They get a 50% penalty. But guess what? If they didn't provide you that safety harness, you only get a 10% kicker. So the law is really disproportionate. So the employer is doing something wrong and not providing you something that's safe for you, you get a little bit of a boost. But they violate the law, it's a 50% penalty. You lose half your benefits. And remember, we're going to get to this in a moment, but you're only getting 2/3 of your average weekly wage. So you're not getting a lot to begin with. Another thing they'll do is you'll cut off your thumb at your distal joint, and it's worth 20 weeks of pay, and they say, okay, we're going to give you 20 weeks of pay, you've lost your thumb. That's what they stand on. But your hand is worth 150 weeks. So that's what separates us from the apes, okay? If you don't have a lawyer, you're not going to know to go in there and say that your entire grip strength is off and that everything's bad. So I'm just looking at my meat chart real quick, and we'll go through all the numbers again in a moment. But for instance, your knee is worth 160 weeks. So if you get your leg cut off at your knee, they want to offer you 160 weeks of pay. So they're offering you 3 years of pay to lose your leg, and then they think they're done. And that affects clearly your whole body. It affects your walk and your back and your mind, your psyche. So that's another part of the conspiracy. Primarily, we handle auto accident cases, truck accident cases, and large injury cases in the civil arena where you get a jury. But it's possible to have a work injury and a civil case. You could be driving at work and get rear-ended, and then you have a workers' compensation case. If you're in your car and you get hit, you injure your neck, let's say, you have both a workers' compensation case as well as a civil cause of action. And here's the conspiracy. There's something called subrogation. So if you win that workers' compensation money, let's say you win 100 grand in workers' compensation, and then you win $1 million from the person that hit you because you had a neck surgery, you got to pay a portion of the $100,000 back. I've written an article on that called Missouri Workers' Compensation Subrogation. I've taught other lawyers and judges even what's called continuing legal education programs, how the workers' compensation subrogation works. But you don't get to collect twice. That's part of the conspiracy. You collect once, and then you collect again, and you pay back the work comp folks. So good lawyers try to get subrogation waived. I do that all the time, and I can explain it to you if you're here, if you have both a civil and a workers' compensation case. We'll do that to your best advantage, but because of the way the math works, you got to resolve the comp case first. And the fee on workers' compensation in Missouri is mandated by the Code of State Regulations at 25%. That's called the CSR. So if we get you 100 grand, the fee is 25. Some people think that we charge too much or earn too much. I never take a fee on benefits we don't earn. So if you're already getting your medical, we don't take a fee on that. I don't find that right because lawyers have a bad name for that sometimes, and we just don't do it. If you're already getting paid while you're off, we don't take a fee on that because that's not right. We only take a fee on the disputed benefit. So if we fight for it and get it for you, then we take a fee on it. In that rape case, we had a pittance of an offer and we won a tremendous amount. They were offering us pennies. And the same on that Dale Weeda. I think the Dale Weeda offer was $7,000 and we got the equivalent of hundreds of thousands of dollars. Because I had a doctor that said the problem wasn't caused by work, degenerative and stuff like that. So there's always a fight in these cases, and but sometimes we lose them. Sometimes we win, but we lose. When I was a very young lawyer, I tried a case for a meat cutter that had carpal tunnel, and he had the surgery, and we won pretty good. We got the award, and he came to pick up his check, and he shook my hand, and he gripped it like a vice. And I felt like I needed to take a shower afterwards. I was so disgusted that I was used to pursue a claim that probably wasn't virtuous based on his handshake. That was 25 years ago. So if your case is real, bring it to us. We want it. If it's not real, or if you're exaggerating, I don't want it. We don't want it in this office. We got too many other legitimate cases with legitimately injured people that we don't want a fraudulent case. I don't want to participate in that. I don't want you to participate in it. Bad cases harm the entire system. The judges don't like them. The other attorneys don't like them. I don't like them. It brings all my cases down. If I try a case that's not worthy, I don't like it. I will if we're stuck with it, but don't lie to me. If you lie to me, it takes the energy out of my sales, and I don't want your case. So now we're going to turn for a moment, and we're going to talk about what I call the meat chart. We'll talk about the state average weekly wage. And again, we primarily handle civil cases where we get a jury. And this is a case from a client of ours that we resolved after filing a lawsuit for millions of dollars. This is a car versus a truck. And Cantor Injury Law is proud to have offices both in St. Louis as well as in Columbia, Missouri. We want to serve the entire state of Missouri, not just the St. Louis market. So if you're injured anywhere in the state of Missouri, we're here to help you. So now we're going to talk about the meat chart. This is the disability chart promulgated by the Division of Workers' Compensation. And you can see that the distal tip of the thumb is worth 45 weeks. I may have misspoke earlier. The third finger and the middle finger and the first finger are 30, 26, and 26 weeks of pay. So that means if you got your finger cut off right here, they'd want to give you 26 weeks of pay at 2/3 of your average weekly wage. You look at this, for instance, the ankle. A lot of people come in and they've got an ankle injury and a surgery and they've got a pin. The defense wants to call it frequently 110 weeks of pay. So if you get a 10% disability, they're offering you 22 weeks. Of course, they always have a 1 or 2 or 3 or 4 or 5% rating. Normally, not always, but normally. And we send you out, we get a 40% rating. So we try to call it the 150 or the 155 week level. My job as your lawyer is to maximize your recovery while doing it honestly and ethically. But you can see that this meat chart doesn't provide any money for pain and suffering. Your wrist is 175 weeks, your elbow is 200 weeks, your shoulder's 232 weeks. Okay, so if you tear your tendon in your bicep and they reconnect it at the shoulder, they want to say it's at the 210 week level because this is where your bicep is. And of course, we want to say it's 232 weeks of pay. So this is the meat chart. Every part of the body is broken down. Complete loss of an eye is 140 weeks. So Missouri used to have the second injury fund, by the way. If you went off to war and were working for the United States Army and you lost an eye and now you come back to work and you lose your other eye, we would have the second injury fund come in and compensate you. But the second injury fund is significantly changed and basically gone for prior injuries. Your eyesight is worth 140 weeks of pay. I don't know anyone that would voluntarily lose an eye for 140 weeks of pay. I mean, workers' compensation is absolutely ridiculous. And we've got hearing loss, but if you lose that eye, and now you can only see out of one eye, and let's say you can't drive and you have other problems, you're having headaches, you might also have a psychiatric claim. Psychiatric cases are not delineated on this chart. Where do we compensate someone for their mental anguish? Workers' compensation is worried about your ability to work. Now, I do have clients with psychiatric injuries, and we've prevailed in those, and one of them was an eye injury. A woman shattered a piece of glass and came up into her eye. They paid us far, far, far more than 140 weeks of pay. Workers' compensation is responsible for 3 benefits. 2/3 of your wages while you're off, 100% of your authorized medical care, and then a lump sum payment for permanent and partial disability. And this is just talking about that lump sum. That's all I'm talking about right now. I'm not talking about future medical. I'm not talking about past medical. I'm not talking about the time that you're off work. I'm talking about the lump sum payment. So your body as a whole is worth 400 weeks. If you herniated disc in your neck and their doctor does a surgery and says, you know, you had pre-existing degenerative spondylolisthesis. It's not related to work, but I did the surgery, so I'm going to rate you at 1%. They're offering you 4 weeks of pay at 2/3 of your average weekly wage. That's what their doctor thinks about your fusion. Our doctor might say you have a 50% disability. So that would be 200 weeks. So where's the truth? It's probably someplace between those two numbers. All right, one of the other tricks, by the way, someone has a fusion and they're 65 years old and that nurse case manager is whispering into the doctor, well, I think they want to retire. No, you didn't want to retire. You may not be able to work, but that's not retirement. It's not like I wanted to go fishing. It's that you're permanently and totally disabled. They like to call that retirement if you work for an insurance company. It's not. Don't ever agree that you've retired willfully. You can't work. That's something different than retiring. You're permanently and totally disabled. If you have a good lawyer, they're going to send you to a vocational expert. They're going to send you to their doctor. And they're going to get an opinion of what your disability is and how that disability applies to your vocation. Okay? If you're a truck driver, and you herniated disc and you can't drive a truck, you're not retired, you're disabled. There's a difference, okay? And don't let them fool you into saying that you're retired. All right, the next part of this, so this is permanent and partial disability. Now we're going to talk about temporary total disability or permanent and total disability. And I'm going to scroll down on my screen over here. So right now, up to June 30th, 2019, if you were injured at work and you made, a fortune, the most you could get a week is $947.64. So if you're making $3,000 a week, 150 grand a year, or 100 grand a year even, this is the most you can get. If you're making 30 grand a year, you're going to get 2/3 of your average weekly wage. Okay, so you're making 15 bucks an hour, you're going to get, far less than that amount. That's the most you can get per week while you're off right now, $947.64. For permanent and partial disability, like the chart that I just showed you, if you got your wrist cut off, you get 175 weeks of pay, maybe a 10% kicker if you got a lawyer. So maybe it's 200 weeks, but it's at least 175 weeks at your wrist times 496.38. That's the work comp formula. You take the chart above. So in this example I just gave, you got your wrist cut off right here. The statute actually provides an additional 10% for the complete loss, but they're not going to tell you that because unless you have a lawyer, they don't offer that up. So you get 175 weeks. At the maximum rate, if you were earning $2,000 a year, a week, it would be 514. So you take 175 times 514. That's what you would get for your wrist. All right, and so 2/3 of your wages is ridiculous. So you got to make sure that you have a lawyer that gets you all the disability that you are entitled to. SAWW again stands for State Average Weekly Wage. In that Sonic case, the rape case I told you about, we set the principal on rate because I pled max rate, and the defense failed to file an answer, and so it was deemed admitted. So the insurance company just said, "Oh, we're not going to even file an answer," but we had said max rate, and so the big debate in that case was what is max rate. They said I didn't define it because I just said max rate. I said, at the time I had a 10-year-old. I said my 10-year-old would understand what max rate means. It means the maximum. And the court and the Industrial Commission, the Court of Appeals, everyone agreed with me, and we set the law in the state of Missouri. It's being constantly challenged, and one day it may be overturned, but that is the law in Missouri. So there are fairness rules that if you have a good lawyer, we can enforce them and make them follow. The burial benefit. You die and you don't have any family. There's a whole body of case law on dependency. So if someone's financially dependent, they get these benefits. But let's say you're out there on your own and you die. The death penalty burial benefit is $5 grand. That's all they got to pay. There's no dependents. There's no family. You die on the job. You fall in a vat of, boiling oil and you die. $5,000. That's a conspiracy. If you drive 99 miles to the doctor and back, do they owe you mileage? The answer is no. It's got to be 100 miles or more. That's the conspiracy. All these laws are written to assist the employer, the large employer, big government, and the insurer. If you're a little man and you have an injury, you need a powerful law firm or you will not be taken care of. You'll be cheated. And sometimes I tell people, even doing my best, I feel like they've gotten cheated because the system is totally unfair. It's the Missouri Workers' Compensation Conspiracy. So again, if you have a serious injury case, I'd like to meet with you. I'd like to help you. If it's real and it's true, I'll fight it. I won't tell you to settle it. I'll take it to trial. I try them all the time. If it's fake, I don't want you. If you know someone that has a real case and needs good lawyering, send them here. Whether it's a car accident, a truck accident, medical malpractice, or workers' compensation. We handle these routinely. We know how to win them. We won't cheat to win, but we will win. And we'll give you our best advice possible. Thank you for watching. I know this was long. I appreciate your support here and on social media. 314-628-9999 if you want to call or have any questions. Thank you.